Welcome everyone to another live episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. I'm Susan Engel, Senior Staff Attorney and Consumer Law Unit Head here in the Greenville office of South Carolina Legal Services. And I'm joined by our producer, Kenneth Elliott, in the background, who always keeps all those trains running on time for these episodes. So welcome in. Before we get started on our topic for today, which is judicial versus non-judicial foreclosures, I do want to remind everybody that this is not legal advice. This is just general information for the public. But if you do have need of a lawyer in a foreclosure or any other legal situation, you can always apply for our services here at South Carolina Legal Services, and we'll be giving you that information here in the presentation. For right now, I want you to look at your screen and scan that QR code if you want to join our information list, where we can send you our newsletter. You can make a donation to South Carolina Legal Services, which is a nonprofit 501c3 law firm, and get other notifications from us about our resources here at Legal Aid. So let's go ahead and get started here. We do have another QR code where we really want you to suggest topics like, is there something you really want to know about? It could be a major topic, it could be a small topic. Like today's topic is kind of narrow, and we can do big topics and little topics. So scan that QR code and send us what you would like to hear from us. There's still many, many things out there that we can cover, even though we are well surpassing, I think, or at least reaching 150 episodes. And as always, we want to let you see that Connect card where all of our information is, as far as contact information, is located. How you can apply, all of our social media. I always like to say nowadays that we're on TikTok, where all the, I think, Gen Zers are, and other folks too. But also, please do note that you can apply for our services by telephone, but you can also do it online 24/7. So we will show you that information again later. So today's topic is judicial foreclosure versus non-judicial foreclosure. What's the difference? And actually, why do you need to know? And this topic came up, recently in some discussions, and not too long ago, I was in court in a foreclosure case, and an attorney said to the judge, well, Your Honor, these are just a bunch of internet defenses. Now, they were legitimate defenses in that foreclosure case, and I didn't find them on the internet, and they were definitely legitimate defenses. But it does remind me of how many people who are facing foreclosure and maybe don't have a lawyer, and they have to resort to whatever information that they can get, and most often that's on the internet. Well, the rules are different in different states. We're here in South Carolina, so today I'm mostly going to be talking about judicial foreclosure, because that's what we have here in South Carolina. But it's important to know the difference, because not all states are the same. The important difference that we'll be talking about today, not the only important difference, but it's an important one, is the difference between judicial foreclosure states and non-judicial foreclosure states, and how those foreclosures are handled based on those two options. Now, if you're in South Carolina and you're trying to find that information on the internet, I do want to recommend, of course, all of our resources here in South Carolina. But anytime you're looking for information like that when it comes to foreclosure and you're in South Carolina, it's important to know that we are a judicial foreclosure state. But we will link to other information that we have about foreclosure here in South Carolina to make sure that you have all that relevant information as well. So let's get into it. So you failed to make your mortgage payments. Now what do? Okay. I think everybody knows that's when foreclosure happens. It's a process by which a bank or mortgage lender takes back a house that they gave financing for or a mortgage on and sells the house to pay the balance of the loan because the homeowner isn't paying it and is significantly behind. Okay, so that's what's usually going to happen, but it does happen in two ways. It can be a judicial foreclosure state or a non-judicial foreclosure state. Here is a little rule of thumb about those two things. If it's a judicial foreclosure state, then the home loans are secured by a mortgage. So when you buy a house, you get a deed in your name and you give a mortgage back to the bank. And in non-judicial foreclosure states, the home loans are secured not by a mortgage, but by something called a deed of trust. So if you're doing your research about foreclosure and you're in South Carolina, if it's talking about a deed of trust, that's not going to help you. Those procedures are not going to be relevant in South Carolina. Okay, so what are the types of foreclosure? Non-judicial and judicial. I've already kind of hinted at what the difference is, but it's non-judicial foreclosure is also called foreclosure by power of sale. And that's because that deed of trust has a power of sale clause in it that allows that lender to sell that home to get their money out of it when you're behind, but they don't have to go to court to do it. In judicial foreclosure, that process has to go through court. That's what we do here in South Carolina. If you're getting sued for foreclosure, it has to be through the courts, has to go before a judge who has to have a hearing and say, yes, this person is behind on their mortgage and their home should be foreclosed on, the mortgage should be foreclosed on, and the house sold. So that's just the basic difference. So how do these two types of foreclosures work? That's, I think, important to know because, again, when you're doing that internet research, some of these terms may pop up and you want to be wary. And if you're in South Carolina, be sure that you're talking about judicial foreclosure. So let's talk about how judicial foreclosure works. That's always going to be in court. So you get behind, your lender files the foreclosure lawsuit, you get served with the lawsuit. It's a summons and a complaint, something called a lis pendens, which is notice to other people that that foreclosure sale or that foreclosure has been filed on that property. One little note I want to make here, we often hear clients who are afraid that because they are quote unquote in foreclosure, that as you often see on the internet, there's going to be a big sign in their yard that says foreclosure. That's a kind of a stock picture that we see on the internet. That does not happen, at least not in South Carolina. Okay, so don't worry about there being a big sign stuck in front of your yard saying foreclosed. But again, you as the homeowner, if you get sued for foreclosure, you can either let that happen if you've given up and you don't feel like you're going to be able to keep your house. I discourage that, of course. Or you can contest it in court. Now, you have to file an answer if you're going to contest the foreclosure, because otherwise, you're not just in default on your mortgage, but you're in default on the lawsuit because you didn't answer it. And the mortgage company can go straight ahead to a very quick hearing at which a judge decides that your property should be sold to pay that mortgage off. So it's important to file that answer because it does give you some opportunities for things that we'll talk about in a minute. But the main opportunity is for things to slow down a little bit so that you can work with your mortgage company, or so that you can have a trial where you're participating and you have maybe some defenses or things that you want to bring up in court. So if it ends up going up for sale, that's usually done by the court here in South Carolina. It can be done by various, officers of the court, including the judge. But if nobody buys the property, and that does happen sometimes, if nobody bids on the property, the mortgage company usually is going to bid an amount that's up to what is owed to them. Because they don't have to pay because they've got that offsetting mortgage, but they're going to pay up to what you owe on the mortgage, but not beyond that. Because if somebody bids a higher amount, they're happy as they can be because that person's money is going to go into the court and then come to them to pay off that mortgage. If you do contest, then the judge is going to have a hearing and listen to your defenses and decide if that's enough to stop that foreclosure and somehow, find in your favor that there shouldn't be a foreclosure or a sale. Sometimes also you get to that point in court and your lender or their attorney may be willing to let you reinstate the loan if you have the money to bring it current, or they may work on a modification for you, and that happens a lot nowadays, so it's definitely well worth filing that answer and getting some of those opportunities to keep your home from being sold and foreclosed. Okay, let's talk about how non-judicial foreclosure works, because it is important to know the difference so you don't get confused when you're hearing what other people say, or you're listening to the news, or you're doing that internet research. So in non-judicial states, as I said, it's not a mortgage, it's a deed of trust. And so that gives authority to the trustee of that deed of trust to foreclose on the house if you get behind and haven't made those mortgage payments. Now, there's a lot of different states that are non-judicial foreclosure states, and they have sort of their own rules and regulations. They can be similar, but some are different. So that won't apply to you if you're in South Carolina, but it is, I think, important to to realize that. So you get behind in a non-judicial foreclosure state, what happens is they will serve you with, or that says mortgage lender, but it's that trustee who will serve you with that notice of default. At that point, usually in most states, it's 120 days to reinstate the loan by bringing it current. But if you can't do that, or if you can't work out some sort of modification or payment plan, then the next thing that happens usually is you get a notice of intent to sell the property on a specific date. That's not a court process. Even then, the non-judicial foreclosure, it can be conducted, the sale can be conducted really by any entity or individual that mortgage lender requests. It's kind of up to them because they're in charge at that point. So now that you know all that, can you stop the foreclosure? There are ways. So don't give up, file that answer. Let's talk about how to stop it. All right, in judicial foreclosure, this is the one we're most interested in, of course, because we're here in South Carolina. There's some things you can do before you get sued. There's some things you can do after you get sued. So before you get sued, find a way to pay the past due amount and get that mortgage current. Okay, you're behind. If you don't catch up, foreclosure is on the horizon. So do what you can, beg, borrow, don't steal, and get that money together to bring it current, even if you have to get a second job or something like that. Now, another thing you can do is to work with your lender to modify that loan, because it may be that, and lenders understand this, it may be that your hours have been reduced, so you're not making as much. You can't afford that payment that you've been paying all this time. Maybe you had to go to the hospital for a period of time, or maybe you lost your job for a period of time. Something got you behind and you're not able to make that same mortgage payment like you used to, and you can't really afford it. A modification modifies your loan to a more affordable payment for you based on what your income is. And there's still a lot of modification going on in the mortgage industry. So I definitely encourage you to look at those options. And, you know, if you can get a lawyer to help you at least look over what options you're considering or getting ready to choose, I think that can be really helpful because it can be confusing. The other thing that you can do prior to foreclosure, if you feel like you do have some defenses, maybe you're not really behind, maybe you haven't gotten credit for payments you've made or something of that nature, there's a procedure called RFIs and NOEs. RFI stands for Request for Information, which is something you send to the mortgage company to, you know, find out what payments they've credited to your loan account. That way you can compare that to the payments that you have evidence that you've made and make sure you're getting credit for everything. That's one of the ways you can use a request for information. You can also request information about how they're handling your escrow account and things like that. And then if there is something wrong, you can do what's called a notice of error, and that's also sent to your mortgage company to notify them about the error, and then they have a certain amount of time to do something about it. And if they don't, then you can force their hand, usually with a lawsuit, so hopefully it doesn't come to that. But our lead foreclosure attorney, John Oslin, did a Level Up Law episode on this, these RFIs and NOE, so we'll link that in the description when we post this video of this episode to YouTube. So if that's something that you feel might be useful to you, he goes through that process for you. Now, after being sued for foreclosure, what can you do to stop the foreclosure? Well, for starters, you can answer the foreclosure complaint, okay? And make sure that you look at it very closely. A lot of people will just say, well, I admit everything, I just got behind on the payments because I was in the hospital. Okay, that doesn't really stop the foreclosure. So you have to challenge what's being said in the foreclosure, especially if it's not correct. But either way, answer the complaint so that there's not this rush to default judgment against you, because that can happen really quickly and mainly without your participation. So if you answer the lawsuit, you're going to be participating in that final hearing in whatever way is appropriate for you. So you may have some defenses to the foreclosure, and you want to put those in there, especially if you were able to get information in that RFI and NOE process. Okay, so also after being sued for foreclosure, try to get a lawyer. You know, that's really important because it gives you the ability to have a little bit more level playing field with the other side in that foreclosure lawsuit, because, you know, quite often, even with that awesome internet research, you really don't know what all your rights are in that process, and a lawyer can help you with that. So definitely, you know, try to get a lawyer. But if you're failing that, definitely check out our resources here at South Carolina Legal Services on our websites and our social media. We are always putting out a lot of information when it comes to foreclosure and things like that. Okay, so moving on to an actual trial, if you are defending that foreclosure and you filed an answer, even if you don't have a lawyer, but if you do have a lawyer, you want to just go ahead and have that trial and bring up those defenses, give your own testimony about what you think or why you think that foreclosure is not appropriate, even if it's just because you paid all the payments, whatever it might be. You need to go ahead and have that trial and give your testimony. While you're waiting for the trial and while all of that is kind of stewing, you could be trying to gather the money to bring that payment current. You know, sometimes you've gotten back into that number of hours at work that you were used to, and you've been able to put that money together. And one thing I might add here that sometimes people don't do, maybe even oftentimes people don't do, is when you're in foreclosure, don't stop making your mortgage payment. Now, you can't make it to the mortgage company because once they hold you in default and they're proceeding on with a foreclosure lawsuit, they won't accept your payment. But keep making that payment as if you still have the mortgage, and that will help you to gather that money so that at some point, hopefully, you can reinstate the mortgage. I think that's a really important thing to do because that amount of money can skyrocket, and it's important to try to be putting that aside. Now, the final nuclear option to stop a foreclosure is bankruptcy, filing bankruptcy. But the important thing to note there is that in a bankruptcy, if you're trying to save your home, you're still going to need to be making the mortgage payment. And it's typically going to be in a Chapter 13 bankruptcy where you take that arrearage, that past due amount that you owe, and you make payments on that to the bankruptcy trustee, and then that gets paid out to your mortgage company. But in the meantime, you're still having to keep yourself current on all those other payments. So bankruptcy is not a fix in the way that you might think, because you still need to be making those mortgage payments, and you've got to be making an extra payment beyond your regular mortgage payment to clear up that past due amount. Right, stopping a non-judicial foreclosure is very different. It's similar before you get the notice of default, in that you want to try to bring it current, pay that past due amount, or try to do a modification. Those are always available, whether it's judicial or non-judicial foreclosure. But if you're not able to do either one of those, then you're going to move on to that next after a lawsuit stage. But again, in non-judicial foreclosure states, the mortgage company is not going to sue you for foreclosure. They can sue you for foreclosure. They can do it judicially, but it's much better for them to do it non-judicially, and that's typically how it's going to go. At the same time, you know that they're holding you in default, and they're notifying you of the default and the potential sale of your property. So what you as a homeowner have to do in those states is to actually file your own lawsuit. And in those lawsuits, you're basically asking the court to issue an order that stops that sale that the mortgage company or the trustee is trying to make happen. And you give your reasons, just like you do with defenses in a foreclosure lawsuit when you're being sued. And you present to the court why the foreclosure or the sale, not foreclosure, the sale, the non-judicial sale should go forward. And sometimes you can get an order that is stopping that sale if you have been able to make your case. Along with that, you typically file a motion for a temporary restraining order. What that's doing is restraining the sale from taking place, that you've been notified probably that it's going to take place, or that that's the ultimate goal, and you want to stop that. It's a temporary restraining order and a preliminary injunction to stop that process that they're going to be taken against you while you have your lawsuit of your own going on in court to show why that sale shouldn't happen. So that's a totally different type of process from what we see here in South Carolina in judicial foreclosure. Other options also exist in non-judicial foreclosure states. Trying to get that loan modification, trying to reinstate the loan, which is really just bringing it current. And then in non-judicial foreclosure states, and here's where you can try to redeem your property after the sale happens. And then again, bankruptcy is also available in non-judicial foreclosure states. Final option, we sometimes call it that nuclear option, because that's, you don't want to go there if you don't have to. But Again, you're going to have to keep making that mortgage payment or that payment on the deed of trust on your house, and you'll have to pay that arrearage, make some kind of payment towards that arrearage. And it's important to know a little bit about that process. And also in bankruptcy, we always have to keep in mind, when you file a bankruptcy, it covers all your debts and all your assets. So you can't just file bankruptcy on your house. It has to be on all of your debts, whether they're secured by a home or a car or something like that, or if they're unsecured like credit cards and medical bills and things like that. You have to list all of those. They all have to be included. Keep that in mind. People don't always realize that. All right, let's recap. Judicial foreclosure requires that the lender obtain that judgment from the court before your house can be sold. So that whole process needs to be gone through. Sometimes people don't realize that. They get a letter from their mortgage company that says, you're in foreclosure. What that means is you're just in a different set of loans on their books, okay? You're not in foreclosure such that your home is about to be sold out from under you. The timing of these is often really confusing for folks. Now, the non-judicial foreclosure, that allows that lender to just go ahead and sell your home without going to court. But again, we went over the ways that you can try to stop that. And as we said, every state does allow the judicial process for foreclosure, but not every state, including South Carolina, has procedures for non-judicial foreclosure, because that's not how we do mortgages here. We have the deed of mortgage instead of the deed of trust. Again, in a judicial foreclosure, the lender is going to be suing you in state court in order to sell your home, and that's how they get back what's owed to them on that money. In the non-judicial, the lender sells the property without having to go to court. So that's an important difference here that I think it's important for you to remember and to know about when you are researching how do I stop the foreclosure. Make sure if you're in South Carolina that you know it is a judicial foreclosure state, and don't pay attention to that stuff that talks about a deed of trust and power of sale and restraining order and all of that. Hopefully this has been helpful to everyone. I'm going to look here and see if we have any questions. I don't see any questions, but you can feel free when we post this video on our YouTube channel, which I'm sure producer Kenneth will do quite soon for you. Feel free to put questions in the comments below, and if it's something that we can answer, we certainly will, or we'll refer you to a resource that might be helpful to you. Once again, here's how you can apply for our help here at South Carolina Legal Services. We handle a lot of different kinds of cases, and you can go to our website at sclegal.org and learn more about the kind of cases that we handle. But foreclosure is definitely one of them. We do a lot of that. Okay, and here's just a quick QR code. You can just scan it and go right to our website application site right on your cell phone. Really easy to do. And you can do that 24/7. You don't have to wait on the telephone or anything like that. So we're real proud of that system, thanks to Tom Trent, the managing attorney of our intake office. He does a great job there. All right, here's one more chance to scan the QR code to sign up for our newsletter and the other information that we send out by email. Please check that out. And I want to thank everyone for being here, to whether it's live or on the replay. We appreciate you wanting to learn more about the law, and in this particular episode about judicial versus non-judicial foreclosure. We really appreciate the audience being here. I thank Kenneth Elliott, our producer, always helpful getting us started and keeping us going. And remember that we will post this to our YouTube channel. So if you want to look at it again, or maybe there's something you missed, that will be there, and we'll get it out there as quickly as we can. Kenneth can be really fast on the trigger with those. So thanks for joining us, and be sure to tune in next week on Tuesday at noon for another episode of Level Up Law. Thanks for joining, everybody. Take care.